So the accused, Paul Ungili Babu Owino, was initially charged with two counts. In count one, he had been charged with the offense of attempted murder, contrary to section 220 of the Penal Code. And the particulars were that on 17th January at a B Club, Galana Plaza in Kilimani area, he unlawfully attempted to cause the death of Felix Odhiambo Orinda by shooting him on the neck. This charge was compromised, and it was withdrawn under section 204 CPC on the 14th of December 2021. In the second count, which is the charge facing the accused now before this court, the accused is charged with the offense of behaving disorderly while carrying a firearm, and the particulars of the offense are that on the 17th day of January 2020 at B Club, Galana Plaza in Kilimani area within Nairobi County, while carrying a firearm, make a style pistol, serial number 3159039, he became disorderly and fired one round of ammunition with intent to shoot Felix Orinda. In support of the charges, the prosecution called a total of 10 witnesses. After the close of the prosecution case, the court found that the accused person had a case to answer, and the accused person chose to give sworn evidence. He called 4 other witnesses. And in his defense in brief, he denied that he shot the accused and stated that there was no witness who saw him direct his gun to Felix Orinda. The other witnesses called by the accused person are Felix Orinda, the victim in this matter, who testified that he was a DJ by profession, and was working at B Club at the time. He stated that he interacted with the accused person, Babu Owino, who was a friend of his for a long time. He stated that on the material day they had no squabbles, that while having a conversation with him, he had a gunshot which caused injuries to him, but stated that he did not see the accused person with a gun. He stated that the lights had been turned down, and therefore it was a bit dark, and he did not see where the gunshot came from. He stated that he later learned that the accused person held him to hospital. He stated that the accused person had been supporting him by taking care of his hospital bills, his utilities, and well-being from the time the incidents happened. The other witness is Edwin Gandhi Otieno, a personal assistant of the accused person, who testified as to what happened on the material day and the day before. The last witness, sorry, not the last one, but the fourth witness was one Charles Ochieng Otieno, a security officer also employed at B Club. He stated that he was the one who used to handle guns that were left by patrons who visited the club while armed, and testified that on the 16th of January 2020 at around 11 p.m., the accused person arrived at the club with the security people, and that he deposited his firearm with him. He stated that around 7 a.m. while in his office, he saw the accused person being assisted by someone to carry another person to the parking area, that he went to the armory and took the accused firearm, which he released to him. The last witness for the defense is Henry Owino Jode, who testified that he was a cleaner at Gossip Club. And he, on the 17th of January, he was at the club at around 7 a.m. with his boss, Godfrey Mwai, who requested him to accompany him to B Club, where he had been called to. And when they arrived at the club, they found the accused, Babu Owino, at the parking with DJ Wolf, who appeared sick, and they say the accused person requested them to escort or to take them to hospital. After the close of the defense case, the defense filed written submissions while the prosecution chose to rely on the evidence on record. The defense identified two issues for determination. First, whether the accused person was behaving disorderly, and second, whether the accused fired one shot with intent to kill the victim. On the first issue, the defense cited Black's Law Dictionary on the definition of disorderly, which is described as a manner that is contrary to the rules of good order and behavior, violative of the public peace or good order, turbulent, riotous, or indecent. The defense submitted that the accused had visited the club with the intention of having a meeting and hanging out with his friends, and throughout the entire night, none of the witnesses, including the prosecution witnesses, could testify to the effect that the accused was disorderly. The defense submitted that the prosecution failed to adduce any evidence to support the allegation that the accused was disorderly, that in fact, contrary to the famous belief, the accused person actually consented to taking a blood test for the purpose of establishing the level of alcohol in the system, but the report never saw the light of the day. They further submitted that several items were collected and swabs were taken with a view to confirm the intoxication status of the accused, but a report was never produced from the government chemist on the analysis. The defense submitted that had the report been produced, it would have found that the accused was not intoxicated as alleged, and that is the reason the prosecution failed to avail the report. The defense relied on the case of Patrick Mutungi Njue versus Republic, where the learned judge held that in a charge under Section 33(1) of the Penal Code, it was not enough for the prosecution to adduce evidence of disorderly conduct, but must prove that the person was drunk and that the arresting officers had the obligation to take the blood samples of the accused and take it for testing of the alcohol content, which was not done in this particular case. On whether the accused fired one shot with the intent to kill the victim, the defense admitted that there was no single witness who corroborated the allegation that the accused fired one shot with the intention to shoot Felix Orinda. The defense also submitted that the ballistic expert could not determine whether the recovered bullet from the scene was a match to that from the accused firearm. The defense admitted that evidence on record was clear that at the time of the alleged offense, the accused was not in possession of his firearm, which was deposited at the armory of the club, and the victim himself testified that he had been friends with the accused over the years, and as such had no motive to shoot him. The defense further submitted that the accused showed that his gun was faulty on the particular day after it had jammed at the shooting range the previous day, and therefore he could not have fired the victim. The defense further submitted that the standard of proof in criminal cases in Kenya was proof beyond reasonable doubt, and the prosecution had failed to prove its case to the required standard. The defense relied on the case of Wilmington versus DPP 1935 AC, 462, Miller and Minister of Pensions, 1942 AC, and the Nigerian case of Bakari versus State, to underscore what proof beyond reasonable doubt meant. In regard to the CCTV footage that was produced in court, the defense submitted that the same had lost its evidentiary value and remains unreliable and inadmissible to the extent of the Evidence Act, and that even if it was admitted, the court ought not to attach any probative value to the same as per Section 106B4 of the Evidence Act. Regarding the certificate of electronic evidence produced by PW9, the defense submitted that the same was electronically signed and the witness did not have a certificate of electronic evidence to authenticate the electronic signature as provided under Section 106C of the Evidence Act. The defense also submitted that the witnesses testified that the CCTV footage was initially stored in a flash disk before being transferred into the DVD, but the flash disk was not produced in court and was not mentioned in the certificate. The defense took issue with the fact that the CCTV footage of what allegedly transpired had been circulated to the social media before the investigating officer got hold of it. It was not clear how it had been obtained from the club and suspected that the same had been interfered with before the investigating officer collected the same. They also submitted that the network video recorder was also not produced in court as exhibit. The defense submitted that PW9 was not the custodian of the CCTV equipment from where the CCTV was extracted, and they could not vouch that the same were in proper and good condition. They also submitted that PW9 admitted that he could not see any gun from the CCTV footage that he was producing. In conclusion, the defense submitted that the prosecution had not proved their case beyond reasonable doubt, and that it was a shame that the prosecution witnesses were blatantly contradicting themselves. The defense admitted that the prosecution had failed to prove that the accused had behaved disorderly while carrying a firearm, as none of the prosecution witnesses could corroborate the fact that the accused behaved disorderly. They relied on the case of Republic versus Edward Kirui, where the accused was acquitted, though captured on film as appeared to shoot the two victims, when the firearm examiner concluded that the fatal bullet was discharged from a gun that was different from the one which the accused had. The defense submitted that the prosecution failed to avail evidence to show the accused was drunk, and that the evidence of the waiter serving the accused cannot be used to prove the accused was drunk without toxicology report. The defense finally submitted that there was no evidence from any of the witnesses to show the accused was carrying his firearm inside the club, and they urged the court to find the accused not guilty and acquit him. It is our cardinal principle of law that in a criminal case, the legal onus is always on the prosecution to prove the guilt of an accused person. And the standard of proof is proof beyond reasonable doubt. The burden of proof, therefore, lies on the prosecution throughout to prove the guilt of an accused person, as provided under Section 107 of the Evidence Act. In the case of Philip Zakawatu versus Republic, it was held that to find conviction in a criminal case, the trial court has to be satisfied of the accused person's guilty mind beyond the accused person's guilt, beyond reasonable doubt. And in the famous case of Milan versus Ministry of Pensions, Lord Denning stated with regard to the degree of proof beyond reasonable doubt that the degree is well settled, it need not reach certainty, but it must carry a high degree of probability. Proof beyond reasonable doubt does not mean proof beyond the shadow of doubt. The law would fail to protect the community if it admitted fanciful possibilities to deflect the course of justice. It is evidence, if the evidence is so strong against a man as to leave only a remote possibility in his favor, which can be dismissed with the sentence, of course it is possible, but not in the least probable, the case is proved beyond reasonable doubt. But nothing short of that will suffice. Having considered the evidence adduced in this case and the submissions by counsels, I find that there are facts which are not contested in this matter. One, there is no dispute that the accused person was at B Club from the evening of 16th January 2020 to the morning of 17th January 2020. Two, there is also no dispute that Felix Orinda was a DJ at the club, and on the material day he was on duty, and that he met and talked to the accused person that evening or that night. There is also no dispute that Felix Orinda was injured on the morning of 17th of January 2020 while at the club and was rushed to Nairobi Hospital by the accused in company of staff from the club, and that the accused has been meeting his medical expenses to date. There is also no dispute that the accused had carried his firearm to the club, though he claims that he left it at the armory of the club before entering inside the club. So the issues for determination, my view are as follows. Before that, whereas the prosecution alleges that the accused got drunk and behaved in a disorderly manner on the material day by firing and shooting Felix Orinda, the defense denies the allegation, in particular that the accused became drunk and disorderly, and also denied that the accused shot Felix Orinda. The issues for determination, therefore, are one, whether the accused was drunk and became disorderly. Number two, whether Felix Orinda sustained a gunshot wound, and if so, whether he was shot by the accused and whether the accused had the intention of killing him. And C, whether the denial by the accused that they committed the offense can stand. On the first issue, Section 33 of the Firearms Act, which the accused is charged with, provides as follows, and I quote, that any person who is drunk or who behaves in a disorderly manner while carrying a firearm, to which Part 2 applies, shall be guilty of an offense and liable to imprisonment for a term not exceeding 1 year, or to a fine not exceeding 10,000 shillings, or to both. As to whether the accused person was drunk, there is no doubt that the environment in which the offense is alleged to have taken place was at B Club, a social joint popular for food and drinks in Nairobi. The CCTV footage played in court from the club showed people drinking and smoking. The accused person denied that he was drinking alcohol, but his friend, PW5 Elvis Ochieng Ogola, testified that he was drinking alcohol with the accused, and further, PW7 Curtis, who is a waiter at the club, testified that he was the one who was serving the accused person with drinks, and confirmed that the accused person was taking tequila, which is an alcoholic drink. I therefore find the denial by the accused that was not taking alcohol not truthful. Although the evidence of these two witnesses above indicated the accused was drinking alcohol, there was no evidence adduced on the state of sobriety or otherwise of the accused person. The description given in the first part of Section 33 of the Act is that the person must be drunk. It is not enough for the prosecution to adduce evidence of disorderly conduct, but must prove that the person was drunk. The arresting officers were under an obligation to cause to be taken a blood sample of the accused and take it for testing of alcohol content. None of the prosecution witnesses, including the investigating officer, spoke of the state of the accused, whether he was drunk or not. In the case of Patrick Njue versus Republic, it was held by the High Court that in cases of this nature, arresting officers are under obligation to cause to be taken a blood sample of the accused and take it for testing of alcohol content. It emerged from the evidence on record that the investigators of this case may actually have been alive to the foregoing, and apparently they took blood samples of the accused person and even swabs from the glass the accused was said to have been using. These were defense exhibit 1 and 2. The exhibit memo, however, does not show that the investigating officer desired to know the alcoholic content in the blood samples of the accused, and in the end, even the DNA sampling report was actually not produced in court as an exhibit. In the absence of the above tests and results, the prosecution did not establish the aspect of drunkenness on the part of the accused person. On whether the accused person behaved in a disorderly manner, the term disorderly is defined in Black's Law Dictionary as a manner that is contrary to the rules of good order and behavior, violative of public peace or good order, turbulent, riotous, or indecent. In the case of Mohammed Faisal and 19 others versus Henry Kandi and others, that is a constitutional petition number 14 of 2017, Justice Ruben Nyakundi cited the following cases while considering the interpretation of what constitutes disorderly behavior. He cited the New Zealand court case. In the case of police versus Christie and Melsa versus police, where the court held that disorderly manner is behaving in a way that right-thinking members of the public would consider inappropriately annoying to members of the public. Since behavior was the focus of the section, and to behave meant to conduct oneself with the propriety, he considered that disorderly behavior was to conduct oneself in a manner which contravenes good conduct or proper conduct as recognized by right-thinking members of the public, and which well-disposed persons would stigmatize and condemn as deserving of punishment. He also cited an American case, Allegate versus Commonwealth, which he stated embodies the liberal definition of what constitutes disorderly tests of the offense. The court held that a person is guilty of disorderly conduct if, with the purpose to cause public inconvenience or annoyance, or recklessly creating a risk thereof, he or she engages in fighting or threatening or in violence or tantrums behavior, or makes unreasonable noise or offensive course or gesture, or addressing abusive language to any person present, or creates a hazardous or physically offensive conduct by any act which serves no legitimate purpose of the actor. As stated earlier, in this case, the alleged offense took place at a B club on the dawn of 17th of January 2020. The prosecution lined up several witnesses who were in the club in support of its case. These witnesses included security officers at the club, some patrons who were drinking in the club with the accused person, and the waiter who was serving the accused in the club. None of these witnesses, however, testified of any of the above elements of disorderly conduct on the part of the accused person while at the club. The only evidence touching on the conduct of the accused person that evening was from the investigating officer, who was not at the scene. He stated that he arrived at the conclusion that the accused person conducted himself in a disorderly manner by a review of CCTV footage that was played in court of what transpired at the scene, and stated that the accused person was seen arguing with Felix Orinda, and that then the accused fired his gun and shot Felix, who fell down. These facts were disputed by the defense, who stated that there was no such argument between the accused and Felix, and that the accused did not shoot Felix. They called the accused himself, the victim, who stated in his evidence that there was no such argument. The law places an obligation upon the prosecution to prove each and every element of an offense beyond reasonable doubt. The mere fact that the accused admitted to having carried his gun to the entrance of the club and having had gunshots on the night in question does not absolve the prosecution from this legal burden of proof. In this case, in order to prove actus reus of the offense, that is the act of shooting the victim, as against the accused, the prosecution must prove, firstly, that the victim was shot and wounded by a firearm. Secondly, proof must be tendered of the type of firearm and ammunition the accused had. And lastly, proof must be tendered that it was a shot fired from the accused's firearm which shot the victim. My view is that the prosecution did a woeful, shoddy job in regard to this when it comes to proof of the foregoing. To begin with, it was stated that the victim sustained gunshot wounds and was taken to Nairobi Hospital. However, inexplicably, there was no medical evidence that was tendered by the prosecution to show what injuries the victim sustained and the cause of those injuries. The investigating officer appeared to have been relying on the CCTV footage, but in my view, the images on a CCTV footage or statement by the victim that he was shot cannot be substitute for medical evidence. The primary evidence that ought to have been produced to prove the victim was shot by a gun was the medical report or a duly filled P3 form to confirm that the victim had suffered a gunshot wound. The court cannot be left to rely on conjecture. In any event, when the court looked at the CCTV footage that was played in court, the background was quite dark, though the counter where the accused was standing with some people was a bit clear. The accused person could be seen from the clip as he was talking to several people around him while smoking what appears like shisha. The view is mainly of the accused's left side of the body, while the right side is on the dark side and cannot be seen clearly. A certain lady in a brown jacket appears on the left side of the accused person and prevents a full view of what exactly the accused was doing, save when he intermittently moved back and forward. During the conversation at one point with the people around him, the accused points something towards the other side, which is dark. Someone falls near him shortly afterwards. The clip did not come with sound, and therefore there was no sound heard of what exactly transpired. From the clip, you cannot tell with certainty that what was pointed by the accused to the dark side of that area was a firearm, and it is not clear where the accused got the object. In fact, the investigating officer on cross-examination stated that he could not be able to see or identify the accused's gun from the clip. As stated above, the investigating officer in his testimony states that prior to this, the accused was arguing with Felix Orinda, the victim. He, however, did not state what they were arguing about or how he got this information, as the clip did not capture Felix Orinda until the time was being picked from the ground and being taken out of the building. In the absence of any other witness who would give an oral account of what transpired, I believe that the evidence of Felix Orinda himself is very crucial evidence, as he was a victim of the said shooting and could have seen what transpired before the incident. Surprisingly, the said Felix Orinda, who was expected to be a key witness for the state, as even confirmed by the investigating officer, was not a prosecution witness. In fact, the investigating officer on cross-examination stated that he did not record a statement from Felix Orinda, the victim of the alleged shooting, and one wonders whether it was deliberate or a case of negligence, as he did not state that the said Felix, he did not state that he approached the said victim for purposes of recording a statement from him and refused. The said victim, however, turned out to be a key witness for the defense. In his testimony, he testified that before the incident, he was talking with the accused and did not see him with a gun. He also stated that he had no squabbles with him and that they did not quarrel. He stated that he suddenly had a gunshot which hit him, but could not tell from where it was fired. He, however, stated that he was told that the accused took him to hospital. The evidence of the victim therefore discredited that of the investigating officer. It is noted that the prosecution alleges that a bullet head and a spent cartridge were recovered from the scene. The investigating officer stated that he was not the one who recovered them and could not recall who recovered them. He, however, stated that the bullet head was recovered from a wall at the scene. He did not state the location of the wall from where the bullet head was recovered and the distance from where the victim was lying. My question would be, Why did the investigating officer not avail the person who recovered the bullet head and cartridge in court to testify? Was it not necessary to confirm that they were found at the scene where the alleged incident happened and confirm that they were from the accused firearm? If the bullet head was recovered on the wall as claimed, was it not necessary for the ballistic expert to visit the scene and adduce evidence on the possible trajectory from the point where the victim was shot? Was it not necessary to avail medical evidence to show that once the victim was shot, the bullet actually exited from the body of the victim and could have landed on the wall as claimed? Having seen the CCTV footage, was it not necessary to avail evidence to show that from the angle the accused was standing, it was possible to recover the bullet from the wall where it was allegedly recovered? These, to me, are important questions which ought to have been considered and addressed by the investigating officer during investigations. And this is where I reiterate that the investigations herein were shoddy, as very crucial areas were not covered. It cannot also be denied that bullet wounds can provide some information about the type of firearm used, caliber, bullet type, and trajectory after the incident. And the investigating officer ought to have availed this evidence. In his testimony, the investigating officer testified that the recovered bullet head and the cartridge, together with the accused firearm, a pistol serial number 3159039, a magazine and 9 rounds of ammunition, were forwarded to the ballistic expert for analysis. PW8 is a ballistic officer and testified in respect of the examination and analysis he conducted on the exhibits mentioned above. He stated that he examined the exhibits and confirmed that the exhibit marked A and exhibits marked C1 to C9 were firearm and ammunition, respectively, and were capable of firing and being fired. He also stated that the ammunition were caliber 9 by 19 millimeters. He also formed the opinion upon analysis of the recovered spent cartridges case that it was found to be in caliber 9 by 19 millimeters and had sufficient breeze face markings, ejector markings, and firing pin identification, which enabled him form an opinion that it was fired from a Mannlicher pistol, like that one of the accused person. In regard to the recovered bullet head, he stated that upon examination, it bore 6 identifiable land engraved areas similar to those found in the accused's gun. He, however, stated on cross-examination that he could not tell whether the recovered bullet head and cartridge case were related. He could also not tell whether the bullet head that was recovered and marked E was shot from the accused's gun. He admitted on further cross-examination that there were many firearms which could use a 9 by 19 millimeter ammunition, like Seska pistols, Glock pistols, Smith and Wesson, etc. The net effect of the evidence of the ballistic officer's evidence was that though the accused's firearm may have been used to fire the recovered cartridge and recovered bullet, there was a possibility of other firearms doing the same, and therefore could not conclusively find that the accused's gun could have, was one that fired the recovered bullet head and a cartridge. It was upon the investigating officer, therefore, to avail collaborative evidence, as the evidence by the ballistic officer could not stand on its own. Having evaluated the evidence available before me and applying the relevant test, it is my finding that the prosecution has not proved its case beyond reasonable doubt. In summary, point out the following factors for the so finding. One, that there was no evidence presented to show that the state of sobriety or otherwise of the accused in the allegation of being disorderly. The victim, two, the victim of the alleged offense denied that he quarreled with the accused and that the accused shot him. C, no medical evidence was presented to show that the accused person, the victim, had been injured by a gunshot. And finally, the ballistic expert did not conclusively find that the accused's firearm was the one used in the act. For the above stated reasons, the accused is found not guilty and is acquitted under Section 215 CPC. And in conclusion, the court notes that this is a case of great public interest that may have gone wrong during investigations, and perhaps the DCI should consider such cases being investigated in future by senior experienced officers, at least in the rank of inspector of police and above.